Good morning, everybody. Thank you for attending this morning's Business Academy talk, Looking Beyond COVID, Legal Pointers for the New Normal. I'm Graham Mead. I'm a partner in the firm's commercial litigation team. This morning's talk really is going to be a roundup of what we have seen over the last sort of 9 months of COVID. Bear with me, it's going to have some mixed content, and I'm going to take a fairly light touch and skip, as it were, through the tulips. We have covered much of what I'm going to talk about in depth in our commercial newsletters, which are available on our website if you need them. So if you want to check out anything, please look there. If there is anything in the talk that you think is worthy of a talk in itself, please let me know, because we're always interested in what to talk about in future talks going forward. I'm going to take questions at the end, if that's okay, just because we have a lot to get through. And as I've said, it's a very mixed bag. So we'll get through, and then if anyone has any questions, we can run through them. So just to begin, it seems to me that the last 9 months has been a very, as it were, mixed time. As I've said here, the best of times and the worst of times. If I'm honest with you, the majority of my clients and those that I speak to have actually had a fairly positive sort of trading period, and have managed to weather most of the storm and are looking ahead. Having said that, obviously on the news and in relation to various events I've attended, and I've spoken to various delegates, and it seems particularly in this, perhaps the hospitality sector, there have been hard times as well. And so it's very difficult to really get a clear picture, as it were, of precisely how things stand. So as I've said, I'm going to run through what I see are potential topics and what we've seen, and how the future will look, hopefully. I'm going to touch on the following main areas: insolvency, directors' duties, contracts, landlord and tenant, and company matters. So to begin with insolvency, we are not really seeing a particular uptake in or increase in insolvencies at the moment. Going forward, I think obviously that's going to depend on how long the government support will continue. We're obviously at that time where we're going to start to see SIBLs and bounce back loans and various other support from the government coming to an end. And based on what the Chancellor is telling us, we're likely to see more unemployment. So potentially there may be a removal of, as it were, money from the economy, which may mean we have to tighten our belts. As with the last recession, I think there's a feeling that there are a lot of zombie companies out there. Those of you that obviously survived the last recession will remember it was an unusual time in that the banks were still a little bit scarred because of the whole RBS scenario. And as a result of that, didn't want to be seen in a bad light. So weren't winding up petitions to, as it were, wipe companies that weren't viable. And I think in a way we're perhaps seeing a little bit of that now. We've got companies that are being, as it were, propped up by government support, but as you also know, statutory demands and winding ups have been suspended temporarily, so they've almost been given a breathing space over the COVID scenario. And so going forward, we anticipate that we may see a change there, and that may increase or have an impact on insolvency. So broadly, it's anticipated that things will harden next year. Over the summer, the general discussions, the general kind of discussions I had with accountants, insolvency practitioners, the legal kind of press, we're all talking about seeing sort of an upturn in insolvency in Q1. Now that seems to be being pushed back to Q2. But I think that's really based more on the feeling that there'll be less money in the economy, so there must be more in insolvency. So we'll have to see, but be vigilant. I mentioned the Finance Act 2020. I know this has been covered in a lot of seminars that I've attended, but for those of you who don't know, Finance Act crept in fairly innocuously and broadly reintroduces the Crown as a preferential creditor. Now, For those of you who don't follow that, basically, if a company goes into liquidation, its debts are, as it were, its assets are sold off, its debts are gathered in, and then if there's a balance left, it's distributed, as it were, amongst the debtors, the creditors. Um, and usually HMRC is a significant creditor in liquidation. So what the preferential creditor status means is that the Crown is one of a preferred group that get paid first ahead of other unsecured creditors. So while I don't see the government wanting to push for more insolvencies, after all, it spent the last 9 months spending a fortune propping up business, I guess the likely upshot is that if is more insolvency, based on what I've said, there is likely to be a smaller distribution, a smaller pot to be distributed amongst, as it were, the creditors. And that's likely to also possibly mean that there is less, as it were, money swilling around. So again, another example of a contraction. It's also worth mentioning, just in passing, and again, this is sort of for another day, but the Finance Act also introduced potential personal liability for directors who are repeat offenders. So if they've had a number of companies that have been insolvent or haven't paid their tax, potentially there is the ability for notice to be given in relation to their personal liability. So I'd flag that just in passing. So the upshot of all of this really, I think, can fall into two main camps. It's either going to be we find ourselves with a kind of almost like a continuing zombie scenario with creditors not wanting to waste money, looking to wind up companies that they're not going to get anything from. Or alternatively, it may be that liquidators and creditors are a little more creative in relation to trying to recover sums of money from other sources if the pot has been reduced. And I suppose one of the key targets in that is likely to be looking at directors for breach of their duties. Now, in terms of legal case law, there has been a recent spate of cases against directors for breaches of their duties. So I suppose it's certainly already starting to hove into view as a potential issue. And that's why really I thought it was worth just having a little touch base on, as it were, directors' duties. So I hear a number of you saying, well, do I really need to worry because wrongful trading was suspended over the COVID period? And of course, that is correct. The Corporate Governance Act came in late June and it suspended wrongful trading, and it also suspended statutory demands and winding up. So again, it gave a bit of a breathing space. And for those of you who attended our last talk actually on the Act, we talked at length about how the government wanted to, give companies the opportunity to sort of see how the land was lying sort of during COVID before they made any rash decisions. And I think this was supposed to give them that breathing space. Now, in September, the Corporate Governance Insolvency Act regulations came in, and they extended the stay, as it were, the suspension of statutory demands and winding up petitions. But interestingly, they didn't extend the wrongful trading suspension. So there was this period, as it were, in between where wrongful trading did kick back in. However, wrongful trading was suspended under these regulations, the Corporate Governance Insolvency Act, suspension of liability for wrongful trading, and extension of the relevant period regulations. And these only came in on the 26th of November 2020. And the suspension will stay in force now for wrongful trading until the 30th of April next year. But my point is, there is, as it were, a 2-month gap there. So it'll be interesting to see whether that actually has any impact going forward. It may not do, as it were, it may just all be swept up, but there is that 2-month period. The other thing I would just mention is wrongful trading, although often cited as being one of the main reasons why directors choose to, as it were, throw in the towel and wind up a company. It's not the only director's duty that can, as it were, bite and catch you. Now, I'm not going to go through all the director's duties this morning in any detail. That is potentially a talk for another day. But I've listed them out here, duty to promote the success of a company, to act within the powers of the company's constitution, exercise independent judgment, exercise reasonable skill, care and diligence, declare interest in proposed transactions, arrangements, not to accept benefits, avoid conflicts of interest, the catch-all, misfeasance, fraudulent trading, as it were, the sister to wrongful trading. These are all still in existence. So all I would say is, just because wrongful trading isn't there, just have your wits about you. And I'm sort of conscious, as it were, that you know, it's one of those things where if you are sort of finding yourselves in financial difficulties, things can happen quite quickly and you have to make decisions quite quickly. So I flag this as kind of, you know, an area. So moving forward, how, if I find myself at the wrong end of director's duties, how is that going to manifest? Well, broadly, the company can bring a claim against, as it were, a rogue director. If the company goes into liquidation, the liquidator can bring, as it were, a claim. And if the shareholders are unhappy, there can be a derivative action. What remedies are likely to be applied for? Well, transactions entered into can be set aside, they're voidable. Damages and compensation can be awarded. Account of profits can also be asked if there's, as it were, a side sort of deal that's going on. You can obtain an injunction to stop or, as it were, force something to happen or not happen, and again, possible criminal sanctions. So potentially there is a lot there. So what should you do if you are a director and you find yourself, as it were, faced with financial difficulties? Well, again, stating the obvious, my own view is, because things can change so quickly, take independent advice early on. We can help with that, or refer you to somebody who can help, as it were, more. Check with your accountant, a good insolvency practitioner, but do, as it were, what I'm saying is, be alert, be vigilant. If you're a director with a specific role, for example, finance director being, as it were, an obvious one, make sure you discharge it well. Often when things start to go wrong, there's a lot of finger pointing. Broadly, however, directors are all liable for board decisions. So, as it were, it's a collective scenario. So make sure you understand your duties, make sure you attend board meetings and that they happen regularly, understand what you're being asked to vote on and sign. And if you've delegated duties to one particular director, make sure that you, as it were, keep an eye on what's going on. I always remember one particular case I was involved in. One director was given a special project. He was telling everybody that they were buying a lot of stock, and then when they went to the warehouse, it was completely empty, and it transpired he had a gambling habit, and it had all been basically a front. So I'm sure that won't apply to you, but just as they have your wits about you. Observe formalities, keep minutes. These are key as to what was discussed and the reasoning behind them. Document transactions. If you objected to a vote, make sure that your objection is minuted, and write to the board by all means afterwards and explain why you're unhappy about things. The court can excuse a director in all the circumstances if they acted appropriately. So evidence can, as it were, come back and be useful to show where you were in the scheme of things. And I suppose then, as a general catch-all, make sure that you take out good directors and officers insurance to give you a safety blanket if that's relevant. I flag here just director duties for potentially insolvent companies. When a company, as it were, goes into liquidation, certain things are scrutinized particularly. Transactions at an undervalue are one. If you've sold property or items at far less than what they're worth, market value, that's likely to draw attention. Preferences, if you pay one creditor before another, or you pay yourself a dividend, things like that obviously lead to questions. If money's been taken out of the company, it can be brought back in by debt avoidance measures. We've talked about directors' misfeasance and breach of duties. We've talked about wrongful trading and fraudulent trading. There is then obviously the risk of directors' disqualification as well if what the director's done is particularly heinous. So just as I say, have your wits about you. I think the point being that much of this, when you're in the maelstrom of it all, it's all happening and you're having to make hard decisions. And I think this is one of those where, again, it's sort of a retrospective thing. So keep vigilant now. Changing to perhaps a more positive note, I just touch on a case that's going through at the moment on business interruption insurance, which many of you may have seen. Broadly, FCA versus Arch Insurance is a case where a number of insurers are involved with a test case around business interruption clauses and their validity. Now, broadly, as many of you will know, business interruption is usually linked to property damage. So you own a factory, the factory burns down, you therefore can't work, and then as part of the deal you claim business interruption to cover, as it were, the period where you're inoperative because of the damage. This case is different. The clauses that are being discussed are non-damage clauses, so they are around COVID. In other words, business interruption caused by, as it were, an unforeseen event. And the general sort of feeling, I think, is that insurers weren't particularly keen to always pay out under them, and so this test case was brought, and the initial High Court finding really was, shall we say, more in favour of the insureds rather than the insurance companies, but the matter has gone to appeal. It's currently with the Supreme Court, and we're expecting a decision on it very soon, probably this year, I think, but if not, certainly early next year. So what I would say is this isn't going to be for everybody. I think I read somewhere that it touches on something like 370,000 policies in the UK, which, given the amount of businesses there are in the UK, isn't really a massive amount, but it would be worth checking your policies just to see whether you have it, as it may be sort of a, good news or something you can look at in the new year. But watch this space, because we are still waiting for the full results of the Supreme Court decision. Now, I now move to contracts. Our commercial team are seeing a large uptake in clients wanting to modernise and update their contracts. We think this is probably because with the sort of downturn in the COVID period, a number of them found their contracts being scrutinised more than usual, or they are probably scrutinising the other contracting parties' contracts more than usual for their own ends. So it's an interesting sort of time. The key questions seem to be obviously around money and getting paid, and around supply issues. Now, I can talk all day on useful terms for contracts, but I touch on the sort of favourites. Exclusion clauses, these are where obviously you look to limit your liability under a contract, perhaps to the contract price as a maximum claim. You can't exclude liability for personal injury or death, and you can't exclude, in certain circumstances, certain consumer, as it were, protections, but you can exclude in other areas. So that would be a good one to have. Payment terms and interest is an obvious one. If you've got 3-month payment terms, you might want to make them a month now. If you've got low interest rates, you might want to look at increasing that if we are looking at perhaps tightening belts. Retention of title clauses, you may be familiar with, where if you supply goods, the title in them doesn't pass to the recipient until you're paid. These are quite good because obviously they allow you to potentially get your goods back, and if the company were to go into liquidation, there's an argument that the goods remain yours, so they're not sold as part of the liquidation. So that's a useful one to have. We're seeing perhaps a little bit of a resurgence in personal guarantees from directors, partners, and parent companies. All I would say is drafting is key in these. Make sure that they are properly drafted, and I would suggest taking careful legal advice. We have seen ones that are downloaded from the internet that involve parent companies and so on. They don't necessarily tick all of the necessary criteria, so just be careful. On that same note, we're seeing sort of escrow accounts where money's paid in and drawn down by the other party. Perhaps more at the moment, something that's coming up in construction contracts. We're seeing monies on account where monies are paid up front. Stage payments when works are completed to a certain sort of point. These are all sort of in the mix, given kind of, I think, the uncertainty that everyone is facing. I suppose the last clause is right to terminate. Make sure you know what has to happen, as it were, before you can press the button to get you out of a contract. And again, perhaps if you've got special circumstances, just make sure that these are tailored to what you're likely to need in all the circumstances. Brexit, you've seen the government's latest campaign, Check, Change, Go. As one of my clients said to me the other day, check what, change what, go where, although he did have some very good recommendations for Boris in relation to where he could go. But all I would say is check the terms of your contracts, just really to make sure they're basic, as it were, Brexit updated. For example, we saw one recently that was really predicated on everything being based around the UK being a member state. So all the terms were about member states and what happened if you were and if you weren't. And of course, a fundamental sort of change like that can undermine a contract in one go. We've had another scenario, for example, where as the particular company was a member state, it only needed to be based in the UK. Now, as it were, if we're no longer a member state and we don't have any special privileges, who knows what's going around the corner? It may be that in that particular case, they needed, as it were, an office in each of the member states. So just, I think it is worth just having a check and making sure that it reflects as far as possible the new and any potential future laws now. Due diligence, we're seeing a number of questions, really the same age-old questions. How do I check the finances, the financial stability of the party that I'm potentially going to be contracting with? Well, the obvious ones are a company search. Type in beta into Google and check that company out if you can. You can perhaps look at their previously filed accounts, although obviously during COVID those have been potentially, as it were, put back and suspended as well. So often we find company searches are out of date and aren't that helpful, but sometimes they are. They can perhaps show an investment of capital or a change there. Credit searches, they're obviously generally quite good, and you get the Delphi rating and things like that. So that's a fallback, but again, a little bit slow. We're seeing a lot of clients praising monitoring services. I mentioned Credit Safe. Other monitoring services are available, but these are ones where they have, as it were, not quite sure how industry intelligence, and if your, as it were, customer client is paying slower, you get a ping in your email, a ping in your inbox saying that their trading position has changed, so that can be quite helpful. Industry intelligence, obviously, if you have a regular sort of meeting of your peers anywhere or a Rotary Club or whatever, that's often a good way of perhaps just finding out what is going on. Or a dreadful word, but gossip. I understand from a number of my building clients that they learn more when they visit the builder's merchant than they do from any other source. So again, I'm sorry to say there isn't perhaps a one size fits all there. And certainly, again, if you're dealing with, non, as it were, limited companies, sole practitioners, partnerships, it's going to be harder to get that information, and there isn't really, as it were, any one-stop shop, one fix. Further clauses just to discuss while I'm on contracts. Force majeure, you've seen a lot about this, I'm sure, in the press, and we've written a lot about it going back to our commercial newsletters. This is effectively a clause which allows a party that's been affected, as it were, by a catastrophic unforeseen event to, as it were, play their joker to get out of performing the contract. All I would say here is they're a good clause to have, obviously, and we're seeing a lot of interest in those being put into contracts. If you have one in your contract, just I suppose check it very carefully. Firstly, you need the clause in to be able to rely on it. So if you're modernizing, put it in. Secondly, make sure that the clause covers what's what the event is. So for example, with COVID, it would need to cover pandemic or epidemic. You can have a general force majeure which says, as it were, unforeseen events, or major unforeseen events, catastrophic events, as it were. And they're perfectly good, but the only thing is they, as it were, put another hurdle in the way, because you almost have to prove it was a catastrophic event and before you can, as it were, get into the ballpark. So if you're drafting, you really want it, I think, to be more specific. Check the clause to see what needs to be done. Do you need to serve notice, for example? I've had clients say, oh, I've got one, but I don't know sort of what I need to do. So just make sure if you're looking to rely on it, you understand the mechanics of it. And also the other thing is check the outcome of the force majeure clause. Sometimes they will give the parties the right to terminate if the, as it were, unforeseen event or the contract problem isn't put right within a number of days. So if you have a lucrative contract, you've had it for years, you don't want to lose that client, you may not want to invoke the force majeure clause, because if you can't correct things after, say, 28 days, it gives the other party the right to chop the contract, terminate it. So just be aware of, as it were, what invoking that clause would mean. The other thing to bear in mind is, just because you have a force majeure clause, you are still under a duty, as with all contracts, to mitigate your loss. Now, what that really means is, and what I'm recommending, is that you keep records surrounding the catastrophic event that's happened. So keep records. If for example, all of your workforce phone in sick because they've got COVID, keep records of the emails that you get from them to say they're sick. Note in your diary when that happened. Explain, as it were, as detailed in as detailed way as you can, sort of what was going on, so you've got a contemporaneous record. Keep records of what you did to deal with it. Did you phone up your temporary recruiter and see whether you could get labour on site? If you were unsuccessful, keep the emails back telling you that it's short, that there isn't any, they're short of staff. If you've managed to drag staff off other jobs, etc., show that you've done that. Show really everything that you can that you've done to mitigate your loss. As I say, keep details of any extra costs and losses that you've incurred in making things right, because again, that's a good sign to a court that you've tried hard. But most importantly, I think communicate, because I find a lot of the disputes that I'm dealing with could actually have been avoided if there had been, as it were, better communication and more openness. I think there's a tendency to want to kind of keep your head down until you know you can sort of turn the corner, and that sometimes leads to issues. So there you go. I mentioned Doctrine of Frustration, which is really yin to the yang of force majeure. If you haven't got a force majeure clause in your contract, you may be able to rely on the Doctrine of Frustration, which operates in a similar way. But I must stress, this is very, very difficult to rely on. And as a result of that, there isn't really a lot of helpful case law. It normally revolves around sort of empire days of when there was a civil war in one of the colonies, so the ships couldn't land to collect the pelts or whatever they were going in for. More modern sort of cases are often around things like oil drilling and sort of unstable governments and so on. So it is a tricky area. But I think with COVID, we are likely to see more cases coming through, and I think we may get more guidance, although having said that, it's too early to actually see a great deal on it at the moment. But in order to rely on frustration, broad terms, you need to be able to demonstrate that what has happened, the event happened after the contract was formed, that it was beyond the contemplation of the parties, that the breach is very fundamental and goes to the heart of the contract, and that because of the breach, the event, as it were, it makes performance impossible, illegal, or fundamentally different from what was envisaged. And I suppose my point is, they're all very high standards and very hard to get home on, but I flag it because I think we may see, as it were, some guidance on the COVID issue and, as it were, non-force majeure Doctrine of Frustration cases going forward. I now take a jump to landlord and tenant. As again, you're probably aware, I mentioned residential just because I appreciate, although this is Business Academy, but I know a number of you run, as it were, landlord sort of businesses, and so this is relevant. Possession proceedings will stay until the 30th of September. Section 21 and Section 8 notices seeking possession have been extended to a minimum period of 6 months, and that stipulation is going to stay in place until March next year. Similarly, with commercial, no forfeiture proceedings for rent arrears are allowed by way of court or peaceable re-entry currently until the end of the year. So again, it's been a sort of a dormant period, an inactive period, and the extra notice is kind of slowing things down as well in that regard. If you do have a case, or did have a case, that was, as it were, extant before the 3rd of August, you can, if for a possession case, reactivate it by serving a reactivation notice. But each case is going to be what we're calling case marked. So you are going to have to supply the court with details of the impact of COVID on the landlord and on the tenant, and the judge is then almost going to triage them in relevance of importance. Domestic violence cases are likely to be put at the front of the queue, and perhaps lesser rent arrears more toward the back. So the upshot of all of this really is we're going to have a backlog to deal with. We're going to potentially have a lot of new cases, and it's likely that the court's going to be slow in dealing with them. And it's also probably likely that it's better that the parties in this situation try and take the initiative to work something out. I mean, court will kick back in, but it's just how soon. The other thing to mention is, as those of you who are familiar with court know, under the pre-action protocols, the court likes to promote jaw, not war. So if you've tried with your tenant, it's probably a good way of actually demonstrating to the court that you're suing as a last resort, which will, I think, show you in a good light. And similarly with a tenant, you'll look as if you've tried rather than just sort of not paying. So again, it may help. Two things to mention there really, just to be aware of. If you are agreeing a lesser rent with your tenant, just try and preserve your voting rights should there be a potential company voluntary arrangement going forward if the tenant is a company, and also just try and protect your position under guarantees. Voting on a CVA, basically you get, as it were, more power the more money you're owed. So you really need to almost be saying to the tenant in a side letter, I'm reducing the rent or I'm accepting a lower rent, but I don't, as it were, waive my right to then sort of look to either recover that later or in a voting scenario. And similarly with guarantees, make sure often the guarantees will operate on the basis that the guarantor only has to pay what the tenant has to pay, and it may be therefore that by taking a lower rent you're sort of preventing yourself from being able to recover money from the guarantor at a later date. But I don't really, a side letter or something may be a way around that, but it will need to be potentially carefully drafted. So just consider that and speak to perhaps one of our property lawyers. I would say that, wouldn't I? Other points of interest for landlord and tenant that we're seeing, that my colleagues have seen, as I said, more creativity really in terms of trying to get around things. Leases seem to be shorter. 5 years seems to be, as it were, the longest. We've seen scenarios where the rent starts low and then moves, as it were, to a higher rent later on. More break clauses to let both parties get out earlier if things aren't going well. We've seen the introduction of clauses which enable a tenant to pay either a lower rent or not pay rent if there is a lockdown or restrictions that prevent them. So, if you're a non-essential shop, for example, you get a pass or a bit of a breathing space during that period. We've seen buyouts with tenants buying themselves out for a fixed sum and landlords buying out the tenant for, as it were, for a fixed sum, so that they can get somebody else in to keep the money, as it were, flowing. So think about what you need, and obviously, as I say, consult with one of us. But it's been an interesting time. What if you can't reach a deal with your landlord or tenant? Well, there's mediation and alternative dispute resolution might be a way to bring you together. You could potentially, if there's a rent deposit, take that rent deposit, but what I'm reading is it's a one-stop shop. You won't, the courts will frown on you're asking for that to be topped up. It doesn't mean you can't ask, but it could be a potential issue. You can issue debt proceedings to recover outstanding rent and combine that with an application for summary judgment. Summary judgment being where broadly the defendant doesn't have, as it were, a valid as it were, defence of the situation. It's just that they can't pay, so you ask for judgment to be entered sooner. So that's something which is still an option. I mentioned this, but I'm probably getting more into the rocking horse teeth sort of section. If you have tenants that have assigned or sublet, as it were, you may be able to go up the assignment chain and come after the original tenants under sort of their past covenants. But these have very strict notice periods. I think you have to notify within 6 months of the debt being due or something like that. And they are sort of, as I say, it's sort of almost a weapon of last resort, but it might be worth looking at that. Recovery from guarantors I have talked about. Commercial, those of you who are slightly longer in the tooth may remember distraining. Well, the modern way of dealing with that is called commercial rent arrears recovery, and there are certain rules around that. But broadly, if there's unpaid rent, it started out, if you had 90 days rent arrears, you could look to invoke CRA, where you send round effectively you give notice and you send round a bailiff to take goods to the value of the rent. On the 29th of September, that's that was extended to 276 days, and on Christmas Day, the quarter days these being, it's going to be extended to the 366 days. So you can only rely on CRA as the periods are getting longer, and potentially you can, as it were, rely on CRA with a subtenant. But again, I leave that there just as a potential option. I think the issue with all of these things is really by taking them, you may be harming the tenant's ability to get back on its feet, which may have more of a long-term problem. So I suppose just, tread gently. Property generally, we've seen a rush to get leases completed, running up to and during and now for the Christmas period, which is good. We've seen an uptake in warehousing. That seems to be very popular. Good warehousing seems to be, as it were, in demand. We've seen a lot of companies, I think, looking to try and get a better handle on they're sort of at the uncertainty and looking to buy their own premises. And we've seen a lot of, well, we've heard rather than seen actually, that pension funds are, as it were, where previously they've been reluctant to release commercial property, they are releasing now. So I don't know whether that's an indication that they see commercial, or certainly perhaps shops and so forth, as being perhaps less of a profitable investment. But it's just a trend. We're seeing downsizing in terms of, obviously, those who kept a full office full of people, they're all now working remotely, and so they're downsizing because they just don't need the space. And finally, the residential market is holding up well, but we think that's probably due to stamp duty being, as it were, the stamp duty being dropped. So as a result of that, it'll be interesting to see whether that continues going forward and whether Boris puts something in place or what happens. But at the moment, it's very busy. Company, I now move to points of interest. I'm pleased to report they are busy. They're seeing really a lot of clients with cash on their balance sheet, speculating and looking to expand and take on rivals and get going. So that's positive. There's been a lot of movement around that. They're also perhaps seeing a bit of fatigue. Some companies have fought through the last recession. They got through the first Brexit shock wave. They're now dealing with COVID. They've got Brexit to come. So a lot of them, I think a lot of the directors and owners are looking to sort of almost cash in their chips potentially and call it a day if they're sort of able to do so. So we're seeing a few more MBOs, management buyouts. We're seeing a few more sales of those types of company to, as I say, sort of outfits that are speculating, looking to expand. It's almost a marriage made in heaven, a company that's not in trouble merging with a company that's not in trouble. But as a result of fatigue, we're also seeing more, or hearing about, I should say, more solvent liquidations. In other words, members' voluntary liquidations, where again, the sort of company is being wound up, but it's not because it's necessarily in financial difficulties. It's just fatigue and owners being able to, as it were, get out now. So that's one thing. Finally, just perhaps a throwaway comment, but third-tier lenders we're seeing a little bit more of as well. I think the main lenders, high street lenders, are perhaps being a little bit more choosy as to who and how they lend to, and therefore third-tier lenders are sort of filling that gap. I'm just told that sometimes their terms are a little more onerous, and they are asking for personal guarantees, which obviously, given the circumstances, may not be unexpected. But that's just, I think, something to mention in passing. So oh, excuse me, sorry, my slides froze, forgive me. So in summary, looking ahead, we think, stating the obvious, there's likely to be less money about next year, but who knows? I know I was in Ipswich town centre on Friday last week, and it was incredibly busy, and driving in there were lots of vans, and it seemed to be business as usual. My wife was in Bury St Edmunds at the weekend, and the town centre was heaving. So, hopefully we could have a swift bounce back. But all I would say is get your house in order from the director's point of view. We've talked on that. Make sure you know what your duties are. From a contract point of view, again, check that your terms of business are, ready and able to protect you, and have an eye on those. Courts are likely to be slow, so potentially be more creative in relation to terms, more creative in relation to perhaps using alternative dispute resolution that we can help you with. as I say, more due diligence, keep an eye out in relation to who you're getting in bed with, vis-a-vis zombie companies, vis-a-vis financials. But I think all in all, based on everything that I'm saying, I think there are still a lot of opportunities out there. As I say, most of our clients, as I say, are doing very well. We're not really seeing them running into sort of insolvency or financial problems at the moment. And property and corporate teams, commercial teams, company teams are busy, as is litigation. So all in all, I think that there's still plenty going on. Well, thank you. That concludes my presentation. If any of you have any questions, please let me have them. If you want to get away, by all means, please email me, and I'll bring up my contact details at the end now on the slide. By all means, ping me an email, and I'll try and come back to you if I can before Christmas. If it's one where it's more to do with company or property, I'll refer it to one of my colleagues and ask them to respond. So thank you. That is it. I'm not seeing any questions, so that looks like you're all sated or have had enough. Hopefully that was helpful. One final point to mention, we will be sending out feedback forms, so that will be very useful if you could complete those and let me have them going forward. So thank you. That concludes everything. I wish you all a Merry Christmas and a prosperous 2021. And thank you again for attending on this cold, frosty morning. Thank you. Goodbye.